5, 4, 3, 2, 1, start. As a matter of fact, with regard to her representation seeking minutes of the meeting as well as the decision taken by the subject experts from the department, no response was personally received by the petitioner. Full stop. Therefore, on receiving the letter of termination, she wrote to the college principal via letter dated 7 June 2018 asking as to whether any communication dated 8 May 2017 as mentioned in the termination order was received in the college. Full stop. The principal via letter dated 10/6/2018 informed that the said letter issued by Director General Higher Education Chandigarh sending documents to her was not received in the college nor could it be found in the records. Full stop. In these circumstances, the petitioner approached this court by filing the instant petition. Full stop. Stanza. Learned senior counsel for the petitioner has contended that the impugned order of termination is violative of the principles of natural justice since the petitioner was not furnished the requisite documents including opinion of experts regarding equivalence of her degree to reply to the second show cause notice and the order was passed before she could reply to the same. Full stop. It has wrongly been recorded in the order that the requisite information was furnished to her. The fact has been denied by the college principal also. Full stop. Secondly, it has been contended that the order of termination is in violation of terms and conditions of the petitioner's appointment which required 1 month notice or salary in lieu thereof before termination of service. Full stop. No such notice or salary was given to her and the service was terminated abruptly. Full stop. Thirdly, it has been contended that 2 other assistant professors who were regularized along with the petitioner as assistant professor commerce wide regularization order dated 11 March 2014 have also similar qualification as that of the petitioner and are continuing on the post. Full stop. Both these teachers possess master's degree in business management as well as commerce and service of similarly placed employees have already been regularized as assistant professor commerce. Full stop. Stanza. Therefore, there was no justification to terminate the petitioner's service. Full stop. Lastly, it has been contended that the petitioner was regularized as assistant professor commerce by the respondents on their own and she has no objection to her service being regularized as assistant professor management on the basis of the qualification which undisputedly has been considered relevant for the subject of management. Full stop. Per contra, learned state counsel has contended that the petitioner along with another contractual lecturers in the college was regularized by order dated 11 March 2014. Full stop. Later, it was found that she had degrees of MBE and MPhil in management and could not have been regularized in commerce as the degree of MBE is not the requisite qualification for the post of assistant professor commerce as per service rules. Full stop. It has further been submitted by referring to rely filed by the respondents that regarding equivalence of MBE degree to MCom degree for the post of assistant professor commerce, a reply was received from 3 state universities declining the said equivalence. Therefore, the petitioner could not have been regularized. Full stop. Stanza. Rest of the averments of the petitioner have not been specifically denied. Full stop. The arguments advanced by learned counsel for the parties have been considered and the case file has been perused. Full stop. There is no dispute on facts that the petitioner, who possesses MBE and MPhil in management, was working as visiting faculty guest lecturer in the college before she was regularized as assistant professor commerce by letter of appointment dated 11 March 2014 full stop. After working on the post for about 1 year, the respondents questioned her qualification for the post on the ground that her MBE degree was not equivalent to MCOM as per report of the subject's experts from 3 state universities and therefore could not be considered relevant full stop. On the basis, the petitioner was issued show cause notice without disclosing the expert's report full stop. Further, the impugned order of termination was also passed based on that report, stating that as per reply received from 3 universities in November-December 2015, the said equivalency was declined by them full stop stanza. Thereafter, a meeting of subject experts from all the 3 universities of state of Haryana, that is KUK, MDU, Rohtak and CDLU Sirsa, was held in the Directorate on 17 April 2016, in which it has been decided that Masters for Business Economics could not be considered for the post of Assistant Professor Commerce full stop. The order is bad in law for the following reasons full stop. Firstly, the order terminating the petitioner's service by considering her MBE degree not relevant to the subject is violative of the service rules, the Haryana Education Group B Service Rules 1986 full stop. Essential qualifications for the post of Assistant Professor Commerce as prescribed in Appendix B to the rules is as good academic record with at least 55% of the marks or an equivalent grade of B in the 7-point scale with letter grades A and F at the master's degree level in the relevant subject from an Indian university or an equivalent degree from a foreign university full stop stanza. It is clearly stipulated that to be eligible for the post, one must possess master's degree in the relevant subject from an Indian university or an equivalent degree from a foreign university full stop. The petitioner undisputedly possesses MBA degree from an Indian university Guru Jambheshwar University of Science and Technology Hisar full stop. Her service has been terminated on the ground that the degree cannot be considered relevant for the post of Assistant Professor Commerce since it is not equivalent to MCOM degree as the experts have opined full stop. Apparently, in terms of the statutory rule of service to be eligible for the post in question, the petitioner is required to possess a master's degree in the relevant subject full stop. It is not the respondent's case that MBE degree is not in the relevant subject, nor has the subject experts opined thus full stop. Experts' opinion has been taken only on equivalence of MBE degree to MCOM and not on MBE being a relevant subject for the post of Assistant Professor Commerce full stop stanza. Equivalence and relevance are two different words having different implications. Equivalence between two things implies they are of the same value, standard or credit having the same effect, whereas relevance implies something being pertinent to or having a logical connection to the other, though the two may not be equivalent full stop. Consequently, not being equivalent cannot be the basis to declare not relevant, and the respondents were wrong in considering MBE degree not relevant for the subject of commerce for want of its equivalence to MCOM degree full stop. Further, the rule requires a degree should be in the relevant subject, which is the instant case is commerce full stop. The subject is vast and cannot be restricted to one of its degrees only full stop. Therefore, they were wrong on both the counts. Firstly, in declaring it not relevant for the subject only because it was not equivalent to MCOM, though equivalence and relevance are different and degree may not be equivalent but still relevant to another, and secondly, in considering equivalence of MBE to MCOM degree and not to the subject of commerce as such, full stop. In the absence of any expert opinion on the degree of MBE being not relevant to the subject of commerce, the petitioner could not have been considered ineligible for the post. Full stop.